So after losing his argument for absolute immunity before the D.C. Circuit Court of Appeals in a rather scathing 57-page opinion, Donald Trump is now telling Judge Aileen Cannon in the other federal criminal case involving his willful retention of national defense information, which is pending in the Southern District of Florida federal court. Trump's telling Judge Aileen Cannon that among the many motions that he intends to be filing on or around February 22nd to dismiss the indictment in that case is alleging absolute presidential immunity, which was just rejected by the D.C. Circuit Court of Appeals. Now, granted, it would be the 11th Circuit Court of Appeals, which oversees the Southern District of Florida, not the D.C. Circuit Court of Appeals, but I can't imagine how more frivolous you can get than asserting absolute presidential immunity regarding stealing national defense information after you leave office. But again, it's going before Judge Aileen Cannon, and Donald Trump tells that to Judge Aileen Cannon in this defendant's motion for adjournment of certain pretrial motion deadlines. And when you go through this 3-page filing by Donald Trump, what he seems to be asking for is that after his pending motions to compel, which Judge Aileen Cannon hasn't ruled on, nor does it seem like she's going to be ruling on it anytime soon, after she rules on Trump's motions to compel, he's then requesting additional time to file a suppression motion, as well as other motions relating to the evidence sought in the pending motions to compel. So saying, can he have one additional month after Judge Cannon rules on the motion to compel to file what's called a suppression motion, as well as other potential motions which he doesn't identify? And I suppose one of the arguments that Trump is going to try to make before Judge Aileen Cannon, and she's such a horrific judge, who knows what she'll ultimately do. The good thing is that her conduct will eventually, once she makes a substantive order, it will be appealable to the 11th Circuit Court of Appeals, but she'll have the opportunity to rule on these various motions by Donald Trump, where he's trying to say that Special Counsel Jack Smith and the Department of Justice and the FBI invaded his rights, breached attorney-client privilege, and engaged in all of this misconduct. It should be noted that with respect to the search warrant executed at Mar-A-Lago, a magistrate judge signed off on it in the Southern District of Florida. Remember that back in 2022 when Judge Aileen Cannon tried to assert equitable jurisdiction over the search warrant that was issued by the magistrate, in the 11th Circuit overturned Judge Cannon back in 2022. And it's also noteworthy that Donald Trump's investigation, or the investigation of Donald Trump that was being conducted, there was various grand juries, and one grand jury that was in Washington, D.C., and issues of potential attorney-client privilege, issues about, any potential, the way evidence was being handled, executive privilege. It was being ruled on by an Article III judge, by a federal judge in Washington, D.C. So all of these motions that Donald Trump tends to bring, or claims he's going to bring, all appear to be very frivolous, but that's not going to stop Donald Trump. And, he seems to want to delay. And here, the motion defendants' motion for adjournment of certain pretrial motion deadlines is just in line with Donald Trump's delay tactics. Let me explain, though, why I think this is also going to backfire on Donald Trump. But just take a look at what it is that he filed here. It says Donald Trump, they call him president. He's not the president. Donald Trump respectfully submits this motion on behalf of all defendants, referring to Waltine Nauta and Carlos de Oliveira. Look at my other hot take where we learned about Waltine Nauta's background, being accused of sexual harassment and other misconduct before working for Trump back in August of 2021. It says, for the reasons set forth below, defendants respectfully request permission to file a suppression motion and motion relating to evidence sought in the pending motions to compel within 1 month of the court's resolution of the pending motion. The special counsel's office opposes the foregoing motions and requests an opportunity to respond. Of course, Special Counsel Jack Smith is going to oppose this ridiculous request right here. It says, pursuant to the court's scheduling order, the deadline for pretrial motions is February 22nd, 2024. Just pause there. We can look at the pretrial order that was issued by Judge Cannon. You see it right here. Pretrial motions, February 22nd, 2024. Then there's that scheduling conference scheduled for March 1 of 2024. In connection with this deadline, the court scheduling order states that to the extent there is an overlap between anticipated pretrial motions and motions in limine not covered in the initial set of deadlines, the filing party should so advise the court prior to the pretrial motion deadline. Defendants currently plan to file on February 22nd at minimum a series of motions to dismiss the superseding indictment and certain of the charges therein. Specifically, although the defense is still evaluating potential motions, we expect to file motions on February 22nd related to inter alia, Latin, it means among other things, presidential immunity, the Presidential Records Act, President Trump's security clearances, the vagueness doctrine, impermissible pre-indictment delay, and selective and vindictive prosecution. And then there's a footnote there. It says, although the motions to compel seek evidence that is relevant to selective and vindictive prosecutions, the defendants will demonstrate on February 22nd, 2024, that there is an adequate basis in the record to require not only full discovery, but also an evidentiary hearing. Just so you know, I mean, what all this means is Donald Trump's playing games right here. This is the type of stuff that any other judge would just laugh out of court. Today's episode is brought to you by 8 Sleep, the high-tech solution to your age-old sleeping issues. 8 Sleep's pod cover slips right over your mattress, bringing heating and cooling tech that keeps you comfortable and sleeping deeper for a better, more restful night. There's nothing worse than tossing, turning, sweating, or shivering in the night because you're not sleeping at the perfect temperature. This is why I love my 8 Sleep, which has greatly improved my quality of sleep and in turn improved my quality of life. Sleep science shows that in order to sleep at our best, our body temperature needs to drop in the early and middle part of sleep and rise in the morning. The pod cover will improve your sleep by automatically adjusting your bed's temperature based on your individual needs. The cover can be added to any bed like a fitted sheet and allows you and your partner to cool or warm your side of the bed as low as 55 degrees and up to 110 degrees. In addition to keeping you at the perfect temperature all night, the pod also tracks your sleep and health metrics. On average, pod users see their sleep quality improve by 32% after just a month on the pod. There's no better way to improve your day-to-day life than better sleep, and the easiest way to do that is with 8 Sleep's Pod 3. So start the new year right and invest in the rest you deserve with 8 Sleep Pod Cover. Go to 8sleep.com/Meidas and get $200 off plus free shipping on the pod cover by 8 Sleep. That's 8sleep.com/Meidas. EIGHTSLEEP.com/MEIDAS and get $200 off. Folks, this was a major game changer for me, and I'm so grateful for my 8 Sleep, and I know you will be as well. But, look at what Judge Aileen Cannon's done related to Donald Trump's CIPA-related motions, Classified Information Procedures Act. CIPA is a very routine statute. I mean, it's, I suppose, complex in the sense of how it's applied to complex issues of national security concerns, but following the steps of CIPA Section 3 Protective Order, CIPA Section 4 Government Withholding of Documents that's not helpful or useful to a criminal defendant that are important national security documents where a substitution can be in its place, CIPA Section 5 regarding the criminal defendants' acknowledgement or statement of the documents that they classify documents that they intend to use at the trial. I mean, this is a fairly orderly process. Judge Cannon's totally botched the CIPA proceedings already. So why do we think that, how's she going to handle these motions for presidential immunity, Presidential Records Act? Trump's security clearances, the vagueness doctrine, impermissible pre-indictment delay, and selective and vindictive prosecution. What are we even talking about? When you left the office, you willfully retained national defense information. There's nothing selective or vindictive or vague about it. There's nothing subject to absolute presidential immunity. I mean, it is so utterly absurd, but Trump saying that he's going to bring these motions on February 22nd and that they would like additional time to file a suppression motion and potential other motions within 30 days after the judge rules on a motion to compel, which is already filed, which Judge Cannon has not ruled on yet. It says, as suggested in the defendant's motions to compel, the defense is considering additional motions with respect to which we are entitled to further discovery, including motions to suppress evidence and or dismiss the superseding indictment based on prosecutorial misconduct, due process violations, unlawful disregard of Trump's attorney-client privilege, Mar-a-Lago raid, and the searches of defendants' electronic devices. For example, evidence sought in the motions to compel may support additional motions to suppress and is relevant to the application of the suppression remedy and good faith doctrine in connection with any suppression motion. The defense should be permitted to make decisions regarding these motions and potentially others based on a complete record. In addition to other pending motions to compel, the special counsel's office produced approximately 21 pages of previously sealed and or ex parte litigation filings and others discovery relating to Trump's anticipated privilege-related motions, despite the fact that these materials are plainly subject to Rule 16e, and although the office has produced numerous other filings, the office failed to produce these materials. I mean, we're talking about what? Donald Trump's own documents with his own people? What are you even talking about? The defendant's review of the recently produced discovery and resolution of the pending motions to compel, as well as the pending SEPA Section 4 motions, will impact our analysis as to whether we pursue and how we pursue some defense motions. Will impact our analysis of whether and how to pursue some defense motions. Accordingly, defendants respectfully request that the court modify the scheduling order to permit the filing of a suppression motion and motions related to the evidence sought in the pending motions to compel within 1 month of the court's resolution of the pending motion. And just so you know, a suppression motion is about excluding evidence from the trial in advance of trial to exclude certain evidence. And so Trump is going to make those arguments. We'll see what Judge Aileen Cannon does. A lot of these issues, once Judge Cannon makes an order, will be appealable to the 11th Circuit Court of Appeals, where she's been overturned twice. Now, folks, why do I think that this is going to backfire on Donald Trump? Because I think and I'm not giving away any secrets here, and it's not like, oh, well, Trump's going to follow what you're saying at this point, because the whole docket's already a mess. But the reality is that, you know, with all of the inefficiencies and lack of rulings before Judge Aileen Cannon, it's going to be impossible to bring her case to trial on May 20th, which is where it's currently scheduled. And so, you know, I think you'll ultimately, what's going to happen is you're going to be able to slot in the case by the Washington, D.C. federal criminal case, whether that's going to be slotted in April or May or June or July. I think that case goes this summer, or shortly before the summer. And I think Judge Cannon's case gets kicked to 2025. And by the time Cannon's case gets kicked to 2025, I think Donald Trump will have been convicted of a felony in the D.C. criminal case. I think he'll be convicted of a felony in the Manhattan District Attorney criminal case. And I think that he will have over $500 million in civil judgments against him. But to be continued there. But that's what Donald Trump is filing on the eve of losing before the D.C. Circuit Court of Appeals on absolute immunity, telling Judge Cannon he's going to bring an absolute immunity motion to dismiss for conduct after he left office and stealing national defense information. It doesn't make sense, but it's Donald Trump, corrupt, criminal, despicable. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. Let's get to 3 million subscribers. Thanks for watching and have a great day.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.